So hey guys, this is Navdeep Singh Chitla. Thank you for clicking this thumbnail. Today we're going to talk about a spousal application, and this is an application which got refused and it went to the appeal division. And then let's see what happens in this. Appellant is a person who is already in Canada and who is a permanent resident or maybe the Canadian citizen, and applicant would be the person who is in India. So the appellant Kulwant Dillon, or he or she made a spousal application for the partner who is in India. Okay, so the reason for the decision introduction we have. So on February the 21st, 2017, the appellant, the person who is in Canada, Kulwant Dillon, filed a notice of appeal against the refusal of a permanent resident application made by his wife, Ranjit Kaur Dillon. Okay, the visa officer was not satisfied the appellant and applicant's marriage is genuine and it was not entered into primarily for the purpose of acquiring status or privilege under the Act of IRPA. So the reason for the refusal by the visa officer are set out in the record. Exhibits include the record and documentary evidence from the applicant, the appellant and the applicant. The appellant's mother testified at the hearing. So let's see the background here. The appellant is a 40-year-old Canadian citizen, Kulwant Dillon, and the applicant is a 32-year-old citizen of India, Ranjit Kaur Dillon. And the appellant and the applicant were married on November the 15th, 2015, and this is the appellant's fourth marriage and the applicant's first marriage. Now, in the spousal application, the visa officers conduct the review about the genuineness of the marriage based on different factors, and they look at the development of the relationship, they look at the supporting evidences, they look at financial aspect as well, they look at the common culture and beliefs and everything, and there are so many other factors, so we're gonna look at one by one here. The first one, they're looking at development of the relationship. So how the relationship started, how did the both parties came across each other and everything. So the appellant and the applicant testified in a consistent manner of the genesis of their relationship, which was facilitated through an arranged introduction of the families by applicant's grandmother, who is a distant relative of the applicant. The appellant and the applicant recounted the timeline and progression of their relationship from the initial contact by the telephone and to meet in person. No inconsistencies and discrepancies arose. The appellant and applicant testified that their first contact by telephone and continued to maintain communication, and appellant submitted documentary evidence of his phone records from January 2015 onwards to corroborate his testimony. So the appellant, who is in Canada, they both started the relationship. Initially they met through the relatives and everything, then they had a conversation by phone and then met in person, and eventually it led to the wedding. And the explanation given around the same is accepted by the immigration board. So given the consistent evidence before me, the officer says, as well the development of the relationship, taking into consideration of the cultural context of the appellant and applicant's relationship, arranged marriage, as well as the straightforward in which the appellant and applicant testified in the initial hearing. I just want to drag your attention towards the officers. Even when you sit for the interview, they also note that your answers to all the questions asked by the visa officer in an interview must be spontaneous, must be in a natural manner. So this is something they look at. They'll also observe your body language. They'll also see if you have already rehearsed about the interview, and they're gonna find out. So you have to be very true, or you have to be very honest about your answers. You must practice for the same in advance. Okay, I find on the balance of probabilities the appellant and applicant's account on how their relationship began and led to marriage to be credible. So the officer is satisfied that the way they started, the way they met, the way they got married, the evidence or the information provided for the same is sufficient, is satisfactory to believe that it's a genuine marriage. Now the financial support, it's also a factor which visa officer look at to establish whether or not the marriage is genuine. So the appellant and applicant testified in a consistent manner of the appellant's continued financial support of the applicant since marriage. The couple also maintain a joint bank account in India, as you can see, and both the appellant and applicant testified that it is the practice of applicant to deposit any remaining money from the appellant's money transfers after expenses have been settled to their joint bank account. So documentary evidence of the money transfers as well as the bank statement, joint bank statement, are included, and I find that on the balance of probabilities that there is a sufficient evidence to establish that the appellant has been providing financial support to the applicant since their marriage. The continued financial support of the applicant supports the view that appellant's and applicant's marriage is genuine. So financial support plays a role in this. So I hope you have understood this particular aspect. Communication: the appellant testified that he maintains regular daily communications with the appellant by telephone through WhatsApp application. The appellant's testimony was corroborated by the applicant, who also testified that she and the appellant speak regularly by phone. An appellant provided documentary evidence of the telephone records dating from January 2015 to November 2018 that corroborate his testimony. So appellant provided all the documentation, including chat history, including call records and everything since the marriage. So further evidence to contact between the appellant and the applicant were submitted in the form of greeting cards. They were using greeting cards. No credibility issues or concerns were raised with respect to the evidence of the regular and ongoing communication between the appellant and applicant. I therefore find that there is sufficient persuasive evidence to establish that appellant and applicant communicate on ongoing basis, which is indicative of a genuine marriage. So this is how you can prove based on the communication that both the partners are having, submitting the evidence about call records and chat history to ensure that the communication is going on, and which is apparently an indicator of a genuine marriage. So visits to India: since the applicant was Canadian citizen and marriage happened in India, it was an arranged marriage. So the visits, the time which both the partners spend together is also very crucial to establish the fact that it's a genuine marriage. So the appellant traveled to India in November 2015 around the marriage. It was during this trip the appellant and the applicant met in person and married. The appellant remained in India until December 2015. The appellant subsequently returned to India in order to visit the applicant in 2016, 2017 and 2018. Every year the appellant returned to India to spend time with his wife, and each of these trips lasted for approximately 1 month, during which the appellant and the applicant resided together. So this, and the appellant testified in a straightforward manner of his trips to India, outlined what he or the applicant did during those trips, which included outing to visit families, celebration of their wedding anniversary, as well as attendance at the applicant's brother's wedding. Ample documentary evidence pertaining to the appellant's trips to India, including passport, airline tickets, boarding passes, photographs, are included in the documents. So no credibility issues or concerns were raised in respect to the appellant's return trips to India since marriage. So the appellant's testimony in this aspect was consistent, spontaneous and forthright. I find the appellant's efforts to visit his wife, to the extent that he has, supports the view that this is a genuine marriage for the appellant and applicant. So now you can understand, the appellant visited India 3 times in 3 years, spent at least 1 month every time. They provided each and every documents for all the outings, anything which can corroborate the fact that couple has got married to start their family instead of. So ample documentary evidence pertaining to the appellant's trips to India, including airline tickets, boarding passes, photographs, were there to corroborate the fact that the appellant was willing enough to spend time with his wife. This is another thing that visa officers look at while establishing that whether or not it's a genuine marriage. So the appellant and applicant's knowledge of each other. Now this is also very important. So the appellant has demonstrated knowledge of the applicant's date of birth, her educational background, her caste, her religion, her family background. The applicant spoke about appellant's previous 3 marriages, the reasons for why they failed, the criminal matters involving the appellant's education, his age, the appellant's family background. No inconsistencies in this area of the evidence arose, and I find that the level of knowledge the appellant and the applicant demonstrated at the hearing is consistent with the genuine marriage. So at the end, if 2 partners are married genuinely, they must be talking to each other probably on daily basis, probably for hours. Even in a general scenario, they must be aware about almost everything what goes on in each other's lives. So it may be about what they do, their daily routine, their background, what happened in the past. For example, the appellant had a marital history, so the applicant had to have the knowledge about that, to confirm that everything was discussed even before the marriage started, even in the initial meeting. That will further corroborate that this marriage started in a transparent manner. Compatibility of the appellant and applicant. The appellant and the applicant share the same caste, religion, cultural background. While appellant may not diligently practice his religion, the appellant is nevertheless of Sikh faith and stated that he goes to temple and prays. Furthermore, although the appellant was raised in Canada, he and his family are of the same ethnic and cultural background as the applicant. And I do not find that simply because the appellant was raised in Canada and he does not maintain a connection with his ethnic and cultural heritage. I find the fact that the appellant has previously entered into arranged marriages facilitated by his family indicates that his close connections to his cultural customs and traditions despite having been brought up in Canada. This is the fourth marriage for the appellant, while the applicant has never been married before. So visa officers also match the cultural background, their age, their beliefs, their education levels and everything, just to ensure that whether or not it's a reasonable match. So in this case, it was the fourth marriage for the appellant. The applicant acknowledged in a straightforward manner that the appellant's three previous marriages and stated that she knew the appellant's marital history at the time of initial introductions. Things are transparent, everything was communicated in the very first step. So applicant was accepting of the testified that the appellant and his parents were honest and upfront about the previous marriages from the very beginning. The applicant indicated her appreciation of the appellant's willingness to provide full disclosure of the past from the outset of the relationship. So the evidence indicates that the applicant simply entered into the relationship with full knowledge and acceptance of the appellant. I find that the applicant testified in the spontaneous and natural manner. This is very, very important because visa officers do take a note of this particular fact, that how spontaneous and how naturally you're answering the questions. So you have to practice. So if you've been asked for the spouse visa interview and you're waiting for the interview and maybe preparing or wondering about what's going to happen, you can get in touch with us. We can definitely help you to prepare for the same. And you must take a note that visa officers will also take a note that answers must be spontaneous and natural, in a natural manner, which means that they're going to take a note of your body language. So there is 8 years of difference in the age between the appellant and the applicant, and both testified that they do not view the age gap as a barrier in their relationship. So the evidence of the compatibility between the appellant and applicant is conjunction with the applicant's perspective of why the marital incompatibility between her and the appellant dissuade her from marrying the appellant, as well as the appellant's and applicant's understanding of each other's character supports the genuine marriage definition. So all the description given about the compatibility of the applicant, about their age, about their religion, about their beliefs, about their knowledge of each other and everything. So this really forms the foundation about the genuineness of the marriage. Length of the relationship. The appellant and the applicant were married in November 2015, and the evidence indicates that the marriage has thrived despite the distance and physical separation. The appellant and the applicant continue to talk daily by phone, and there was no evidence to dispute that the appellant and the applicant remain committed to each other after 3 years of marriage. I find the length of the marriage is a positive factor in assessing the genuineness of the marriage. The future plans, both the appellant and the applicant testified in a consistent manner of their plans to start a family and for the applicant to find employment in Canada. They further testified of their initial plans to reside with the appellant's parents and then the possibility of finding their own home. And the appellant and the applicant also spoke about their plans for the appellant to settle in India should the appeal not be successful. They discussed about the future plans. If not in Canada, they'll settle in India. So this pretty much makes sense. So the appellant and applicant provided consistent evidence in respect, and I find that there is a sufficient persuasive evidence to establish that the appellant and the applicant have discussed their future plans, which is indicative of a genuine marriage. So the appellant's previous marriages. Now this is very important because in this case the concerns were raised with respect to the appellant's 3 previous marriages as it relates to the genuineness of the applicant's present marriage. The appellant recounted in a straightforward manner. This is very important. Again, their answers must be straightforward, natural, without any hesitation of the circumstances of his first 3 marriages. The appellant also testified of his desire to make marriages work. his feelings of being used by his former wives financially. While I acknowledge that there's no evidence from appellant's former wives, there was no evidence that appellant has been investigated by immigration officials in respect to his previous marriages, and there's no evidence establishing that the appellant's 3 previous marriages were not genuine from the appellant's perspective. So the minister's counsel states that the appellant didn't have any children with his first 3 wives, which suggests that these 3 previous marriages were short-term arrangements. I do not agree. The appellant was not specifically asked why he didn't have the children with his former wives. There's no evidence before me to conclude the fact that the appellant didn't have children with his former wives was because of a short-term arrangement in the marriage, as there are a number of reasons why a couple may not have children. So again, it worked positive. Then immigration history. So there's no evidence before me of previous attempts made by the applicants to enter Canada or the other country. Okay. So they also take a note that how many times in the past the applicant tried to enter into Canada. Aside from the appellant and his family, there's no evidence that applicant has close family or relatives in Canada. While the applicant testified of taking an international English language test in 2012, which she explained is an exam to study abroad, any country. So the applicant stated that the test is generally taken in order to improve one's English capabilities and speaking skills. The applicant stated that she didn't seriously consider studying abroad and did not complete any applications in order to do so. So there is no evidence before me between 2012 when applicant completed the international English test and 2015 when she got married that she made any efforts to immigrate to another country. So given the evidence in support of the genuineness of the marriage in conjunction with the lack of evidence of the applicant's efforts to leave India prior to the marriage, I find that on the balance of probabilities there is simply insufficient evidence to establish that the marriage was entered primarily for the purpose of acquiring any status. Here is the conclusion. I find that the appellant and applicant are compatible with respect to their age. There was a difference of 8 years, but still accepted. Caste was same, religion was same, cultural background was same. The appellant and applicant have provided reliable and trustworthy evidence of the origin, development of the relationship, their conduct during the relationship, the demonstration by the appellant and applicant of continuing communication, care and responsibility towards each other. In that, my view supports the case that this is a genuine marriage. So this is something that visa officers are looking for. If your case was refused or if your application was turned down, if they were not up to the mark, maybe you can get in touch with us. We can definitely help you to establish your case. I find that there is a substantial evidence before me in favor of a genuineness of this marriage that supports the view that this is a genuine marriage for the appellant and the applicant, not the one was entered into primarily. So I find that appellant has met his onus to demonstrate that on balance of probabilities, the marriage is genuine and was not entered into primarily for the purpose of acquiring any status. Appeal is allowed. So that's how we do it. So these are the factors which in detail. So overall, the development of the relationship, this doesn't demonstrate that the marriage was entered primarily for the purpose of immigration. You need to provide comprehensive details around the story and also need to corroborate the same, that it was not about migrating to Canada, it was about starting a family and it was a good match and how things went. So financial support that shows care, that shows this is an indicative of a genuine marriage. Again, communication, very important, about daily routine, about all the background, for example, education, daily routine, everything. So all these points are very, very important. See, this is just an example. Every case will be different. I won't say might be different, it will be different for sure. So I take great interest in studying the immigration cases and I'm pretty much into it from quite a while now, and we are greatly inclined to make your application a success. Every application which comes to our office is not just an application. We treat it as we value your dreams, we value your aspirations, we value your future plans, and we value your life. So that's how we take care of your applications. Thank you so much. I'll see you in the next video.